The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to this month's webinar, Maintaining a Drug-Free Workplace. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Leon Frierson, the Publications Coordinator for Personnel Concepts, and I'm joined by my co-moderator, Karen Jonas, who serves as our Regulatory Monitoring Manager.
Hello, everyone. Today's speaker is David Kotler, a Florida lawyer and former Miami-Dade County prosecutor with broad legal experience during his 20 years of practice. He currently focuses his practice on the legal cannabis industry. Since 2014, he has consulted with individuals, investment funds, doctors, and employers. He has also consulted with both nationally known licensed cannabis companies and ancillary businesses operating within the cannabis space, including making applications in emerging regulated markets. Mr. Kotler is a frequent lecturer and has been quoted or interviewed for numerous local and national news outlets, in addition to having had a monthly column in the Cannabis Industry Journal, among other writing engagements. Thank you, David, for joining us today.
Thank you for having me, Karen. Addressing drugs in the workplace is certainly not a new issue, but it's gotten a little more complicated in recent years with the legalization of marijuana in many states and the recent opioid epidemic. In the one sense, employers may feel that state laws addressing marijuana may justify relaxing drug-free workplace policies in some circumstances. However, in many states, the opioid epidemic has grown so troublesome that state and federal agencies are stepping in to address the situation and urging employers to join the fight.
Definitely. We are looking forward to discussing it with you. Now, first, we're going to start off today's presentation with a poll question. We'd like to know why you're attending today's webinar, so please select from any that apply, actually. Are you a federal contractor looking for more information on Drug-Free Workplace Act? Would you like more information on opioid abuse? More information on medical or recreational marijuana use? Or questions about drug-free workplace policies? I'm just going to wait another couple seconds here just to get a few more people voting. All right. I'm going to close and share this with everybody. So it looks like most of you want more information on drug-free workplace policies. And luckily, you're going to learn quite a bit about that. Now, today's agenda focuses on what employers can do to maintain a drug-free workplace. We will begin by discussing the legalization of marijuana and talk about public opinion and the growing popularity of CBD products. We will then examine the various state laws addressing marijuana, including both recreational and medicational use, and talk about how those states protect employees that use it. Next, we will look at the ongoing opioid epidemic, and we will also talk about drug-free workplace considerations and the ins and outs of drug testing. Finally, we will also offer tips for employers to maintaining a drug-free workplace.
And the format for today's webinar features a series of questions that Karen and I will be asking to David regarding maintaining a drug-free workplace. Before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the chat window. Most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. At the end of the session, you'll have an opportunity to use the raise hand feature in GoToWebinar to pose a question directly to our guest speaker. Now, we recognize that marijuana legalization is a sensitive, divisive, and controversial topic for many Americans. All of our presenters today, myself included, will make every effort to avoid using any insensitive language or stating any personal opinions about the subject matter. We also respectfully ask that you use similar discretion if you are given an opportunity to pose a question to our guest speaker. With that, let's get started with today's presentation. Karen?
We know that many states have legalized cannabis use for either medical or adult use purposes, but isn't marijuana still illegal at the federal level?
That's a very good question, Karen, and I guess a good starting point as any. Over the last several years, many states have legalized marijuana in varying degrees. This trend reflects public support of the decriminalization of marijuana. However, under federal law, the possession, manufacture, distribution, and sale of the drug is still a crime. And this conflict between federal and state law that's led to confusion and challenges for many employers.
And how has the legalization of cannabis and the opioid epidemic impacted employers?
They appear to have led to increased usage and positive drug tests. I point to a study conducted by Quest Diagnostic, which reported that in oral fluid testing, which detects recent drug use, marijuana positivity increased nearly 75% from 5.1% in 2013 to 8.9% in 2016 in the general U.S. workforce. It also increased in both urine testing and hair testing. In states that have legalized recreational marijuana, such as Colorado and Washington, the study showed that failed tests have outpaced the national average. Positive tests increased in Colorado by 11% and Washington by 9%. One survey reported that 70% of employers felt some impact from drug abuse, such as absenteeism, use of prescription pain relievers at work, positive drug tests, impaired or decreased work performance. Perhaps an employee's family member has been affected, and many other ways. The Center for Disease Control reports that every 16 minutes there's a death from opioid overdose. Furthermore, it's been reported that 4.5 million Americans are estimated to have a substance abuse disorder involving opioid prescription painkillers, costing an estimated $504 billion per year. Surveys widely vary regarding whether the abuse is more prominent in employees or their dependents. But regardless of who has the substance abuse issue, opioid abuse in the family will likely impact the employee's performance at work.
Thank you for that information, David. We have another question for our audience. Now, we'd like to know how many of you are federal contractors. This next section will be especially important for you who have large contacts with the federal government. So I'll give everybody a couple more seconds here to vote. And then I'll share the results. So it looks like most of you are not federal contractors, but for those 12% of you who have answered yes, this next section is especially important. Now, David, which federal laws do employers need to be aware of in association with maintaining a drug-free workplace?
There's a few laws that are worth pointing out that an employer needs to be aware of when it comes to enforcing drug-free workplace. Frankly, whether your audience or our audience does federal contracts or not. Probably the biggie certainly starts as the Controlled Substances Act, wherein marijuana remains a Schedule I controlled substance and as such remains a barrier to research, to some extent banking, and uniform policies and considerations which must be considered on a state level. Title VII of the Civil Rights Act of 1964, which really forces an employer to be sensitive to the impact of a drug-free workplace program upon groups who are protected under this law. It's important that a policy or program and its procedures not provide even the perception, let alone the practice, of treating any employee differently because of race, sex, religion, or national origin. Company's policy and program must be consistently enforced with employees. Next, we have, I would say, probably the Americans with Disabilities Act of 1990. The ADA prohibits employers from discriminating in employment decisions against a qualified individual with a disability because of his or her disability. A qualified individual with a disability does not include any applicant or employee who is currently abusing drugs or alcohol. The Act specifically permits employers to adopt drug testing and drug-free workplace policies and to prohibit employees from using illegal drugs. However, qualified individuals may include persons who have successfully completed rehabilitation programs or are in a program and are no longer using illegal drugs. And lastly, I want to point out the Federal Drug-Free Workplace Act of 1988. This act requires that all federal contractors who receive $100,000 or more, as well as all federal grant recipients, must comply with its requirements. At a minimum, such organizations must, A, prepare and distribute a formal drug-free workplace policy statement, B, establish a drug-free awareness program, C, ensure that all employees working on the federal contract understand their obligation to notify the employer within 5 calendar days if he or she is convicted of a criminal drug violation. I think I'm on E, notify the federal contracting agency of any covered violation, and lastly, we'll go with F, take direct action against an employee convicted of a workplace drug violation.
Thanks, David. That was particularly informative for our federal contractors here. But in addition to the federal laws, are there also state laws that employers should consider?
Yes, Leon, there is. In addition to the state marijuana laws, which I'm going to discuss a little later in this webinar, certainly employers need to be mindful of additional state laws. And let me talk about a sampling of those that may have some effect. Certainly, there's state testing laws. Some of the laws that the audiences are prone to in states that they're in restrict testing, require specific procedures to be followed, restrict sanctions that can be imposed on employees who violate policies, and authorize private lawsuits against employers, labs, and medical facilities that violate the laws. It's imperative that employers determine what laws, if any, exist in the states in which they conduct business and ensure compliance with those laws. Similarly, we have state anti-discrimination laws. States generally have their own specific statutes addressing discrimination. Federal law requires at least 15 employees on staff to file a discrimination claim, while an individual state law may allow a discrimination claim with as few as one employee. Furthermore, we have state workers' compensation laws. Certain states vary as to legal impact on workers' compensation claims when drug and/or alcohol are determined to be contributing factors. Some states have laws that cause an injured worker to become ineligible for workers' compensation benefits when an employee's injury is caused by the willful and serious misconduct of the injured employee or by his or her intoxication. Similarly, there may be workers' compensation policies that need to be checked in addition to that state law. Many states have also enacted laws that provide financial discounts on workers' compensation insurance premiums to employers who maintain drug and alcohol-free workplace programs.
Thank you, David. Now, are there industry-specific laws as well?
There are. Perhaps the two most far-reaching ones include that are worth pointing out are the U.S. Department of Defense regulations. The U.S. Department of Defense has issued rules and regulations addressing drug testing, which obligate defense contractors to establish and maintain a drug-free workplace program for all personnel who work in sensitive jobs. Similarly, the U.S. Department of Transportation has also issued rules and regulations that require the implementation of drug and alcohol-free workplaces, including drug and alcohol testing by employers in the transportation industry.
Thank you for reviewing those laws with us, David. Now, we've seen opinions on marijuana change under, well, have we actually seen opinions on marijuana change under the President Donald Trump administration?
Probably most notable is the position taken by Jeff Sessions as Attorney General. He's certainly taken a less than favorable approach to marijuana. And despite a subcommittee report that came out of the Department of Justice on marijuana suggesting alternative action, the Cole memo, which was a policy memo that had been guiding U.S. attorneys for a number of years, was rescinded. The net effect of that, despite an industry panic soon after, where I think a lot of folks in the industry thought stormtroopers would knock down their doors, was really limited, other than some drawback by banks and institutional investors that were poised to enter the market last year. Components of the medical and recreational marijuana legalization of particular interest to employers include, and still, under Donald Trump's administration, is to date there have been no obligations under the ADA to offer reasonable accommodation to use marijuana. And employers must still pay attention to the effect that tolerant programs may have on employers which have federal interplay.
Thank you, David. Now, here's another question for our audience. We'd like to know how many employees you have on payroll. We're looking to collect this information to make sure that we're tailoring future webinars to the proper audience. So I'll just give another few seconds for everybody to vote if you can. All right, thank you for those who voted, and I'll share the results. So it looks like most of you are large employers. Now, David, how have opinions about cannabis changed during the past decade?
Well, despite its treatment at the federal level, the medical community and perhaps hand-in-hand the general populace seem to be more accepting of the use of cannabis for the past 10 years, especially medical cannabis. The numbers from the General Social Survey, a large nationwide survey conducted every 2 years and widely considered to represent the gold standard for public opinion research, comport with other national surveys last year and more recently, which found support ranging from the upper 50s to low 60s.
And are there certain groups that are more accepting of marijuana than others?
Certainly appears that way, Leon. There are significant differences between those who approve of marijuana and those who don't condone its use. The General Social Survey indicates two significant fault lines when it comes to marijuana policy: age and political party. Fully two-thirds of respondents aged 18 to 34 supported legalization in the survey, as well as majorities of those aged 35 to 49 and 50 to 64. But seniors 65 and above stood apart, with only 42% supporting legalization. Attitudes regarding legalization seem to have shifted pretty rapidly. In 2008, for instance, only 40% of the youngest respondents and just over 20% or 21% of seniors supported marijuana legalization.
And are opinions about medical marijuana changing as well?
Certainly. After years of opposition and challenges that faced the industry, the use of medical cannabis really appears to be here to stay. In a February 23, 2017 Quinnipiac poll, 91% of voters approved medical cannabis when recommended by a doctor. According to Newsweek, 2016 was the year that the election changed cannabis legalization. A total of 9 states, the most ever, held referendums on marijuana legalization for either medical or recreational use in 2016. And 7 of those measures were approved. The most significant was certainly the passage and legalization of recreational use in California, just by sheer numbers. While the medical community has been slow to embrace cannabis for its medical attributes, it appears to just be a matter of time. There is a considerable body of evidence that medical cannabis may be good for patients, if not better for treating certain conditions than many mainstream medications. Support from doctors such as Dr. Sanjay Gupta and his reporting on CNN to help bring attention to the plight of sick children who benefit from what we call high cannabidiol CBD or low tetrahydrocannabinol THC.
And is there scientific evidence supporting the medical value of cannabis?
There's not tons of peer review evidence based on federal illegality. However, there are thousands of reports and journals, articles supporting the benefits of medical marijuana. According to Americans for Safe Access, more than 6,500 reports and journal articles from around the world support the medical value of cannabis. Hundreds of scholarly articles have demonstrated cannabis's ability to reduce pain, fight nausea, potentially improve appetite, and these other symptoms, with virtually little to no harmful side effects. Even the American Medical Association, which has long taken a very conservative stance on the issue, revised its policy in November 2009, calling for an easing of federal classifications, which make it extremely difficult to study the impact of medical cannabis and obtain the peer-reviewed material that I discussed before.
Thank you, David. Now, are there strains of marijuana that don't get the user high, but still offer beneficial properties to patients?
Certainly, Karen. Much of it anecdotal, based on what we were talking about earlier, and probably this is worthy of an hour's talk, but there are many different chemicals in the cannabis plant. Confusing the workplace situation, which is one of the reasons we're here, even more is the proliferation of cannabidiol, or what we call CBD products. Essentially, CBD is part of the many components of the cannabis plant. It's said to be non-psychoactive, yet contains many beneficial properties as it reacts with the body's endocannabinoid system. Products containing CBD come in many forms. It can be in oils, pills, other ingestibles that are being sold in health food stores or online. They are marketed as a natural alternative to battling inflammation, pain, anxiety, and other ailments. Furthermore, most of these CBD products are marketed as being legal in all 50 states, which we now know is really not true, and really takes on a whole nother area of the law. But the chemical that causes the high, which is called tetrahydrocannabinol, or THC for short, is another component that differs from CBD. The federal definition of industrial hemp is based on a threshold of below 0.03% THC. As such, many of the CBD products marketed across the country could have some level of THC in them, which could cause an employee to fail a drug test, however, not be under the influence. On a state-by-state basis, these substances would even be legal on a federal and state level if that particular state has potentially what we call Farm Act pilot program in place.
And if you don't mind, David, what is the overall outlook of the cannabis industry?
With 31 states and Washington, D.C. having legalized medicinal and recreational marijuana, the cannabis industry is booming. In 2016, it was estimated the U.S. industry is worth more than $5 billion. By 2024, it's expected the industry will be worth over $37 billion.
Thank you for that information on the cannabis industry. Now, can you tell us which states allow recreational marijuana?
Currently, a total of 9 states and the District of Columbia now allow for the recreational, sometimes called the adult use of marijuana. They include Alaska, California, Colorado, Maine, Massachusetts, Nevada, Oregon, Vermont, which is the first to allow by a legislative initiative, Washington State, and lastly, Washington, D.C.
And which states allow medical marijuana?
As you can see on the slide, 31 states in the District of Columbia allow for some type of medical use of marijuana. Each state has a slightly different list of qualifying conditions for medical marijuana use, but most people with cancer, human immunodeficiency virus, HIV, acquired immune deficiency syndrome, AIDS, epilepsy, and seizures can acquire cards or licenses to grow or purchase cannabis for medical use in the 31 states listed, or 32. Interesting to point out states such as Arkansas, relatively conservative state, Louisiana most recently in 2016, and then states such as West Virginia in 2017, which have passed.
And how about states that allow for the use of CBD marijuana without THC or low THC levels?
Right, and we mix terms a little bit by talking about CBD versus low THC, high CBD claims. Some of that which is marketed is actually different from what I'm going to talk about, which are the 14 states that allow what I call low THC, high CBD marijuana for use for patients through a state regulated system. The states that allow industrial hemp or CBD programs for medicinal patients would be Alabama, Georgia, Iowa, Kentucky, Mississippi, Missouri, North Carolina, Oklahoma, which has now progressed beyond that, South Carolina, Tennessee, Texas, Utah, Virginia, and Wisconsin. Each of these states has different requirements regarding the allowable levels of THC and CBD ratios.
Thank you. And now that we've gone over the different states and which states allow the use of marijuana, we'd like to know if you operated in a state that allows marijuana use. If you could select one of the ones that apply, either medical and recreational marijuana are allowed in your state, medical marijuana is allowed in your state, the industrial hemp or the CBD we were talking about with low or zero THC is allowed in your state, or you live in a state that does not allow the legal use of marijuana. All right. Looks like most people have answered. So I'll share the results. And it looks like most people live in a state that allows medical marijuana. So that's definitely very interesting. Now, David, do the states that allow marijuana use have specific protections for employees?
Some do, some don't. Some states are going a step further in protecting employees who use medical marijuana. For example, Pennsylvania, Maine, and in part Rhode Island explicitly prohibit employers from discriminating against employees because of their status as medical marijuana cardholders. In New Jersey, employers need not accommodate marijuana use in the workplace, but their regulations are silent on off-duty medical use. In Arizona, Delaware, Minnesota, and New York, the burden is on the employer to prove the employee tested positive and was also impaired at work. Some states, however, ruled in favor of the employer. Interestingly enough, these are states that seem to have longer standing programs versus some of the newly regulated states. And so, by example, courts in California, Oregon, Washington, Montana, Colorado, and New Mexico have ruled in favor of employers who fired employees for using marijuana in violation of company policy. Find it interesting, kind of the longer they've been around, the less protection for employees or for employees.
And David, just for reference, can you talk about some key court decisions that employers should be aware of?
Certainly, Leon. So far, employers that have challenged express state employment protections for off-duty medical marijuana use have not fared well in some of the more regulated markets. In a Rhode Island case decided in May of 2017, which was Callahan versus Darlington Fabrics and the Moore Company, The Rhode Island Superior Court ruled that employers prohibited from refusing to hire a prospective employee because the employee would potentially fail a pre-employment drug test due to the employee's use of medical marijuana. The court held the state's Hawkins-Slater Medical Marijuana Act, which prohibits discrimination against medical marijuana users, also protects the cardholder's actual use of marijuana. So even though using marijuana is still illegal under federal law, the court held that employers that refuse to hire card-carrying prospective employees due to their use of medical marijuana may be subject to liability under that state's Medical Marijuana Act. The court also addressed and did not find a federal preemption issue under belief that the Controlled Substances Act, which we talked about earlier, and issues in the case could coexist. An even more recent case decided in September of 2018, this year, just a month or two ago, the Knopfsinger versus Bridebrook Nursing Rehab Center case had a similar result. Bridebrook, a federal contractor, made an offer of employment to Caitlin Knopfsinger contingent on her passing a pre-employment drug test. Knopfsinger told Bridebrook that she was a registered qualifying patient under the Connecticut Palliative Use of Marijuana Act, and she had used medical marijuana since 2015 to treat post-traumatic stress disorder. When the pre-employment drug test came back positive, no surprise, for marijuana, Knopfsinger was not hired because the employer followed federal law holding that marijuana is illegal. Knopfsinger filed a complaint in state court, alleging, among other things, a violation of PUMA's anti-discrimination provision. That provision reads as follows: unless required by federal law or required to obtain funding, no employer may refuse to hire a person or may discharge, penalize, or threaten an employee solely on the basis of such person's or employee's status as a qualifying patient. The court denied Bridebrook's motion to dismiss and held PUMA provides a private right of action to aggrieved medical marijuana patients, and federal law does not preempt PUMA's prohibition on employers firing or refusing to hire qualified medical marijuana patients, even if they test positive on an employment-related drug test.
Thank you, David. And I think we may have heard your dog in the background a little bit there. So thank you for the audience just for continuing to listen. So,
Sorry
David,
about
you
that.
did.
We're going to have to kick that dog.
Yeah, anyway, it should be pretty interesting. So you mentioned at the beginning of the webinar that in addition to the recent activity addressing marijuana laws, there's also been an ongoing opioid epidemic. Could you tell us a little more about that?
Of course. While employers have always faced issues concerning drugs in the workplace, especially in sectors dealing with transportation and hazardous activities, the last 6 years, I would say, have been an especially transitional time as we face the proliferation of opioid use and increasing addiction and the concurrent role of out-of-state sanctioned medical and adult use cannabis programs. Ironically enough, this discussion comes at a time when proponents of cannabis use have presented cannabis as a means of curbing opioid addiction. Nowadays, we have added confusion with the number of people taking CBD, which we discussed, known as cannabidiol, which is marketed and sold as a non-psychoactive health alternative and can be found in health stores and gas stations. Whatever one's personal belief is regarding the foregoing, employers must be prepared to understand the facts and address the realities of these drugs and their effect within their respective workplaces. Opioid addiction has reached epidemic proportions, and this has a direct effect on employers. According to the National Institute of Occupational Safety and Health, in 2016, 95% of the 63,632 U.S. drug overdose deaths occurred among the working age population, persons aged 15 to 64 years. The Bureau of Labor Statistics reported that overdose deaths at work from non-medical use of drugs or alcohol increased by at least 38% annually between 2013 and 2016. The 217 workplace overdose deaths reported in 2016 accounted for 4.2% of occupational injury deaths that year, as compared to 1.8% in 2013. It is unknown how many of these deaths were caused by opioids specifically, but workers with a concurrent substance abuse disorder miss an average of 14.8 days per year, while the subset with a pain medication use disorder miss an average 29 days per year. This is in contrast to an average of 10.5 days for most employees, and an average of 9.5 days for workers in recovery from a substance abuse disorder.
Wow, those stats seem pretty concerning for employers, David. Now, is there anything being done to combat this epidemic?
There is. aside from law enforcement efforts, the most recent federal spending bill, which was approved 85-7 in the Senate, provided a $145 million increase for the treatment of opioid addiction, bringing spending to about $3.7 billion to battle what lawmakers called an epidemic of abuse. Communities with a high per capita rate of opioid prescriptions tend to have about 5 percentage points fewer adults active in the workplace, according to researchers at the Federal Reserve Bank of Cleveland that supported that spending bill. The Mental Health Parity and Addiction Equality or Equity Act and medical plan design changes group health plans subject to the Mental Health Parity and Addiction Equity Act, and indicates those plans must provide care for substance abuse disorders like opioid addiction in a manner that meets the MHPAEA parity requirement. On a state level, at least one state has taken steps to encourage employers to welcome opioid-addicted individuals back from opioid addiction treatment into the workforce. New Hampshire recently established an initiative for a recovery-friendly workplace, which is a voluntary program for participating employers to support returning employees to avoid recidivism so the employee can maintain their recovery.
So in light of recent marijuana laws and court decisions, as well as the opioid epidemic, what are some considerations employers should make regarding drug-free workplaces in response to all these changes in marijuana law?
My advice probably comes at no surprise, but in this changing regulatory climate surrounding the use and legalization of marijuana and concurrent drug abuse, no matter what it is, it's more important than ever that employers are diligent about their drug-free workplace policies and procedures. Where anti-drug policies exist, it's pertinent that employers make them more state-specific than ever, as we see, because there's really a patchwork that's starting to develop.
David, do you have any specific recommendations for employers?
I do, Karen. First of all, employers should maintain a zero-tolerance drug policy. The policy should articulate zero tolerance for use of drugs and abusive alcohol use or other illegal behavior. The policy may also allow for discharge or discipline of an employer refusal to hire an applicant. An employee or applicant refuses to submit to a drug test. Make sure to require employees to acknowledge the drug policy in writing. Documentation is always critical of taking adverse employment action. You should also ensure your HR department, if you have one, or similar role if you don't, is aware of what steps should be taken to document violation of company policies. If necessary, utilize progressive discipline. Now, with that said, in light of the Knopfsinger case, employers, including federal contractors, should not rely solely on federal law or their status as a federal contractor when making employment decisions with regard to applicants and employees who use medical marijuana. Courts in Connecticut and certain other states will enforce state laws against discrimination with regard to medical marijuana use. Taking recent case law and evolving opinions into consideration, employers may want to consider accommodations for medical card holders.
Thanks again for that information, David. Now, I do want to encourage the audience to continue to send in your questions if they haven't been answered by our presentation, and we'll do our best to answer those at the end. We'll pose them directly to David. But before that, we have another question for you all. We want to know if your workplace has a zero tolerance drug-free policy in effect. And so it's either yes, no, you're thinking about it, or if you're uncertain. So go ahead and respond to that poll, and then we'll share the results in just a few seconds. So it seems like most do have a zero tolerance drug policy, and just a few uncertain. So that's pretty good as far as that percentage. So back to you, David. How about drug testing recommendations? And if you could give us any information if these should differ by state?
Well, it depends. I'm going to give you the lawyerly answer. Some states have enacted drug testing statutes. So some of the laws restrict testing, require specific procedures to be followed, restrict sanctions that can be imposed on employees who violate policies, and authorize private lawsuits against employers, labs, and medical facilities that violate the laws. It's imperative that employers determine what laws, if any, exist in the states in which they conduct business and ensure compliance with those laws. For employers that decide to drug test employees for a variety of reasons, such as deterring and detecting drug use, as well as providing concrete evidence for intervention, referral to treatment, or disciplinary action. These are considerations which they really must think about.
David, what are some questions employers should consider if they choose to include a drug testing policy?
Sure, let's Let's take a little look at what those would be. So employers who decide their policy will include testing should probably ask the following questions, starting with who will be tested. Options may include all staff, job applicants, and/or employees in safety-sensitive positions. No matter what you choose, it's most important to remember that drug testing policy should be consistent in order to mitigate possible discrimination. The next thing to consider is when will tests be conducted. Possibilities include pre-employment, upon reasonable suspicion, or for cause, post-accident, randomly, periodically, and post-rehabilitation. Most employers choose to test at the beginning of employment, which is fine. Once employed, however, employers should consider what should trigger a test, potentially depending on the type of work or industry. From a risk management perspective, employers need to be more proactive in certain areas, obviously. Ones that entail an employee driving, working in a warehouse, or being in another dangerous setting or working with a dangerous instrumentality. Again, the most important thing is to be consistent and follow the policies and procedures you have laid out. Other considerations: which drugs will be tested for? Options include testing applicants and employees for illegal drugs and testing employees for a broader range of substances, including alcohol and certain prescription drugs. It's important to note that tests for marijuana do not always indicate current impairment, since marijuana can stay in an individual's system for weeks. Thus, an employee's off-duty medical marijuana use could lead him or her to fail an employer's drug test. How will tests be conducted? Different testing modes are available, and many state laws dictate which may or may not be used. This is something you really need to pay attention to. Lastly, what will be the consequences of a positive test? For pre-employment testing, a positive test may result in the rescission of an employment offer. Bear in mind some of the cases we talked about earlier. For existing employees, it may lead to counseling of some sort or even termination. Again, some states offer protection to medical marijuana users by requiring employers to prove evidence of impairment in addition to just a positive drug test.
And can you explain OSHA's policy on drug testing?
Sure. In May of 2016, OSHA issued a final rule to revise its recording and reporting occupational injuries and illnesses regulation in order to improve tracking of workplace injuries and illnesses. Some areas that the final rule addresses include electronic submission of injury and illness data, employer reporting of information to their employer, informing employees of the right to report work-related injuries and illness free from retaliation, and employee access to injury and illness records.
David, many of our attendees may have heard that OSHA actually released a new memo on drug testing. Can you explain this in more detail for our audience?
Certainly, Karen. On October 11, 2018, OSHA released a memorandum clarifying the agency's position on certain drug testing policies and employer safety incentive policies. OSHA states that 29 CFR 1904-35 does not prohibit workplace safety incentive programs or post-incident drug testing. OSHA believes that many employers who implement safety incentive programs and/or conduct post-incident drug testing do so to promote workplace safety and health. In addition, evidence that the employer consistently enforces legitimate work rules, whether or not an injury or illness is reported, would demonstrate that the employer is serious about creating a culture of safety, not just the appearance of reducing rate. Action taken under a safety incentive program or post-incident drug testing policy would only violate 29 CFR 1904-35, and that's actually subsection B14, if the employer took the action to penalize an employee for reporting a work-related injury or illness, rather than for the legitimate purpose of promoting workplace safety and health. It is important to train those responsible on which situations are permissible for drug tests versus which aren't.
And can you explain which type of drug testing policies would not violate OSHA's requirements?
Well, so according to OSHA, the following types of drug testing policies would not violate OSHA's requirements. Random drug testing unrelated to the reporting of a work-related injury or illness, drug testing under a state workers' compensation law, drug testing under other federal laws, such as the U.S. Department of Transportation rules or guidelines. And lastly, drug testing to evaluate the root cause of a workplace incident that harmed or could have harmed employees. If the employer chooses to use drug testing to investigate the incident, the employer should test all employees whose conduct could have contributed to the incident, not just employees who reported the injuries.
Thank you for explaining that, David. Now, here's a final question for our audience. Do you currently conduct random drug tests on your employees? So we have a yes, no, I'm thinking about starting to implement a drug testing policy, or you're uncertain. Let's give everybody a couple more seconds here to vote. Okay, and I'll share those results with you. So it looks like most of you do not currently conduct random drug tests on your employees. Thank you for your responses. Now, David, should employers perform random drug tests in light of the recent developments in marijuana regulations, the opioid epidemic, and OSHA guidance?
I'll take the easy out and say that the decision to perform random drug tests really depends on what industry the employer may be in. Frankly, sometimes there's just a greater need. Most employers confine random tests to employees occupying positions of safety or security sensitivity. Employers who choose to perform random tests should make sure that they have a clear policy on how the tests are administered and the parameters of the test. Again, making sure those are compliant with state law. I guess my last point on random drug testing may sum up this presentation on some level. When making a determination on random drug testing, ask yourself what you want the culture of your company to be. I'm not suggesting you encourage staff to light up a bong in the lunchroom, but what I am suggesting, though, is a commitment to make your workforce feel comfortable in your setting, where they can be inspired to be part of what it is that you do. Use this as an opportunity to perhaps address changing social norms while updating policies and procedures.
All right, David. First off, I want to thank you for your time today. But before we do exit out, do you have any last tips for employers?
I do, Leon. Let me sum up a few, just kind of wrapping things up. Here are my final recommendations, I guess. My first tip would be to identify and analyze your current policies and procedures relating to medical or recreational use of cannabis. You may have multiple policies and procedures relating to such drug use. Make sure they're all consistent. Make sure to be proactive in identifying issues and remedying them. I think a lot of people mentioned they were in states that already had some form of medical or otherwise cannabis related, but if a law is forthcoming in your state, don't necessarily wait until it's passed. Do the due diligence in advance. I'd also recommend that you educate all employees on changes. Be sure to educate supervisors and managers in separate training. You may also want to consider enlisting assistance on issues related to cannabis from attorneys or consultants that have done work related to the issue. This may not be your normal labor law person. Finally, there may very well be a variation on a state-by-state basis as time goes by. Pay attention to whomever you're working with, that they're up to date on state-level issues, certainly on these topics.
Thank you, David, for reviewing this information with us. Before we end today's session, let's take a moment to answer some questions from our audience that were submitted during the presentation. Leon will ask the questions on behalf of our attendees, so go ahead and submit your questions. I also want to quickly mention that if today's webinar has inspired you to implement a drug-free workplace program or policy, or update your existing policy, we can help. Personnel Concepts has a drug-free workplace program, and we just updated it to our second edition. It's designed to help you ensure that your business understands how new legal developments in state marijuana laws and the recent fight against the ongoing opioid epidemic will impact your employment practices. It includes important documentation forms, attorney-written customizable drug-free policies and a legal brief, supervisor and employee training materials, and information you need to comply with state drug testing and marijuana laws. For more information, you can visit personnelconcepts.com. Leon?
Yeah, thank you, Karen. And first off, I want to thank the audience for participating today and also submitting your questions. We do have some great questions, and I'll do my best to pose as many as we can to David, specifically concerning the Department of Transportation. Seems like a big topic that we're getting asked about, David. So I'll group a couple questions here. First, from Julie, and then Steve, I'll follow up with yours. Now, Julie says she has drivers that they hire under the Department of Transportation guidelines, and as an employer, we need to follow those guidelines. What about other employees that work for us that are not drivers? Can they also be a part of those same guidelines?
It can. I mean, I think you could take kind of an across-the-board approach. and part of it may be, what those folks are doing. I mean, certainly when crafting policies and procedures, it's easy just to have a blanket approach. I guess to answer your question directly, I think you could take a cross-the-board approach, but it's not necessarily, unless dictated by the DOT, and that really needs to be looked at on a case-by-case basis. It may not be a necessity, but it's probably the easiest one where you don't start opening yourself up to liabilities to have something across the board, frankly.
And just to follow up with that, do the Department of Transportation and FAA regulations override state laws?
I would say certainly on a level of the usage of particular substances when in those sensitive uses. Now, I think the reason this has become such a difficult area to address is, if you look at the finding in Connecticut recently, the potential would be that there is that they may not. And I think the situation in the case that we talked about earlier on in Connecticut was that really was pre-employment, and she really wasn't going for a safety sensitive use. I'd have to say that I think FAA, Department of Transportation, and some of these guidelines for folks that are working with dangerous instrumentalities probably would override. But honestly, that's not been a tested issue in the courts yet. But I'd certainly want to err on the side of caution and address that on a state-by-state basis, based on where you're located.
And thank you for that answer, David. I believe that would answer Dorothy's question as well. She did ask, even if my state allows medical or recreational use, can we still have a drug-free workplace based on our industry? Obviously, your question was directly about Department of Transportation, but I believe the same thing would apply. Would you agree on different industries?
I would. It highlights the need to really look at it closely. I mean, the problem, again, getting back to marijuana, and maybe it's the time when you craft very specific medical marijuana use policies and procedures, at least. Listen, if a person were to use marijuana with a medical card 3 hours before coming in to drive a fleet vehicle, who's to say that they may or may not still be, under some level of intoxication? And arguably, it's the same thing as alcohol. And so maybe it's a good opportunity to look at, what a across the board drug-free policy would look like versus tailoring it a little more specifically and make it look like how we treat alcohol in the workplace on some level. Can't use it while on duty, and maybe write in areas where one could test for reasonable suspicion of use in a recent manner. And so probably a good time to look at those. Hopefully that answers the question.
Yeah, and I think you also answered Stacy's recent question. So hopefully, Stacy, you were satisfied with that answer. She was asking about using on the job or right before work. So you touched on that as well. I did want to kind of transition, because we're speaking about trying to find impairment or how to establish that. And so Laura asked, what constitutes evidence of impairment? This seems like it could be very difficult to do. And just to add in that, obviously, like in office settings or where there's a low potential for risk or low risk for injuring, like how would you establish impairment or evidence of impairment?
Yeah, I almost derive this answer from going back to my days as a DUI prosecutor, as a young prosecutor in Miami, and really looking for signs of one's faculties being impaired. So are they slurring speech? Are their eyes bloodshot? Do they have a flushed face? Do they have an odor that's coming from them? Is there some effect on their work performance that other employees are potentially noticing? Once you start seeing those kind of things, I think it's important as ever to document, because as we know, whether somebody's impaired is often very subjective, short of having a breathalyzer test or a blood test. And so it may not be on the first instance that you're taking some disciplinary action. The first instance may be documentation, and the second may be, some type of action. So I think those are cues that you might be looking for. And it may even behoove in one's policies and procedure manual to highlight some of those things that could be used to make a determination as to whether somebody is actually impaired at work, or whether there's some type of substance that's affecting their workplace performance. A dangerous job or not, frankly.
And just to switch gears here, it's a unique question that I don't think we have addressed. It also comes from Laura. She it's a little lengthy here, but she says, it's my understanding under some situations, FMLA requires an eligible employee be granted FMLA for drug treatment. What stipulations require that FMLA be granted? And how can an employee be comfortable returning? How can a returning employee be comfortable after just being released from a drug treatment, returning from FMLA and to their employment of providing care to children or providing care to people in the nursing home, for example? So basically, I think she's asked it pretty well. But if they're in a position where they are, taking care and having gone to drug treatment could be, affect their reputation in the workplace, what protections do they have, and is that allowed under FMLA law?
I have to kind of give you a caveat that FMLA is a very, very specialized area of law, and I think we've taken a pretty broad stroke. I'm not sure I can dive deep enough into FMLA to answer the question to Laura's satisfaction, but I can say that it may be incumbent on an HR supervisor or whomever satisfies that role. I don't know it's go around certainly and tell everybody what's going on. I think that could certainly actually violate aspects of FMLA. However, I do think there are certain ways that HR directors and their counterparts can be creative in compliance with FMLA to make sure that employees that are coming off of some type of program are comfortable into the workplace. And that's coming with certain welcome back aspects, checking up and following up with the employee to make sure everything's going well, and documenting dialogue in that standpoint between the director or somebody in the department and that employee. Beyond that, honestly, it's difficult. I think you really have to dig deep into the FMLA to determine what is permissible and not permissible, and on a case-by-case basis, based on the size of the company, the employee, who else is in the division, what may be acceptable to do or not.
Yeah, thanks, David. And I agree. I never had really thought about the link between FMLA and a drug-free workplace. So thank you for tackling that question. I do have one last one before we finish up here from Kristen. If you can give any recommendations, she asks, how do you get around falsifying drug tests? The staff brings, if they were to bring other people's urine, animal urine, or fake urine, if you have ever encountered that or could give any recommendations to her out there.
Probably more anecdotal than anything. I think certainly the more random drug testing or shorter notice drug testing does away with some of that. Making sure that individuals aren't wearing loose and baggy clothing going in pre-urine sample is another way. While collecting samples, certainly there's ways to determine, and document whether a sample is consistent, warm, or otherwise. It gets a little crazy, but that's the reality. I think those are a few ways. Having doing it in a location which takes away the ability. So a person may give a sample in a bathroom behind a stall, but it may be that the person giving the test is not necessarily in the stall, but in the bathroom. Some of that takes away from the ability to swap out samples or sneak them in. So I'd say, clothing, supervision, and documentation of specimen collection. Again, most of those are anecdotal. I've never had to integrally be involved in the collection process. And it may be that companies now also turn more and more to professional companies that do that on a daily basis, and take away the liability from the individual company doing it, and push on compliance and liability onto a third party that specializes in it.
No, thanks again, David. I think that's a good ending point there because unfortunately we have run out of time, and all unanswered questions will be forwarded to David via email, and his responses will be sent out to all attendees in the coming days. I want to thank everyone who submitted their questions about today's topic, and thanks to you, David, for taking the time to answer them. Karen?
This concludes today's webinar. Thank you for attending today's presentation. Please stick around after the webinar to take a quick survey. We appreciate your input in developing future webinars. We hope you found this information useful in understanding how to maintain a drug-free workplace. Thanks again to David for being our guest panelist. We look forward to continuing to work with David on future presentations. To all of our attendees, thanks for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone.